insist on it. We insist on it. We just chew their asses out, tell them, you know, that's why. DLI is one of the main reasons we pick it, especially central offices, because they didn't process the grievance. We don't just pick a superintendent and say we're going to pick it. We just say, hey, oh, they don't process the grievance, we're going to kick your ass, we're going to embarrass you. You've got to let them know you're going to do that, right? So, it says it's specifically prohibited in paragraph 5 and 6 right here, 20-28989.8. And you know the first thing they'll do when they actually make them do a grievance in the DeKalb County or other school system, Dr. Lena, what they'll do, they'll send out the central office person to sit there in the grievance with them. Or maybe in Atlanta, they will pull, if you're filing a grievance against the assistant principal, the principal won't sit in there, right? Then the principal, they might have had one, 4 or 5 people in level 1. Yep. I tell the teacher, I say, go ahead and just let them do it. Let them violate the law, because I'm going to beat them to a pulpit level, too, about violating the law, right? But I've also had teachers, I say, well, what you do? I give them a copy of the law, and I say, just tell them. So, well, I personally object to having this hearing today, because you've got 3 or 4 people here. And here's what the copy of the law says. Give it to me. It stuns them, right? Because the law says specifically prohibited the third person. What's the phrase right here? It says, do not permit the presence of a third person at any level. And then the previous paragraph says at any lower level, third person is specifically prohibited.
So does that mean if you have a grievance with the principal, it should be you and the principal?
Right. Yeah, immediate supervisor. That's what it says in the first sentence. Level 1 over here, it says you file a grievance with your immediate supervisor. It doesn't really define immediate supervisor. But I say if you're mad at the assistant principal treating you in a way that violates policy or statutes or whatever, you file against the assistant principal, and the assistant principal should be sitting in there because they're talking to you. But because what did the preamble say, the first paragraph? With the least formality, right? At the lowest possible organizational level, and they use also the lowest administrative level. 2 times he used the word lowest. One time he said lowest administrative level, one time the lowest possible organizational level. It says so that good morale may be maintained, that the students may be better, the community, to enhance, let's see. It says so that good morale may be maintained, effective job performance may be enhanced, and the citizens of the community may be better served. That's the whole purpose of this, is to try to resolve it. We said with the least formality, remember? It says these procedures require local units of administration to implement a simple, expeditious, and fair process for resolving problems at the lowest administrative level. But it says with a minimum conflict and formal proceedings. Well, when you start sending somebody over from the central office, you formalize the proceedings. That intimidates the teacher, right? That's why you need an advocate group like MACE to tell you what to say to them, give them a copy of the law. Then they do it on the color of law. They knew what the law was, and they violated your rights under the statute. Because it says right here, remember in paragraph 4, go back there, it says, a statement that the complainant shall be entitled to be heard, to present relevant evidence, and to examine witnesses at each level. They've denied you this entitlement right there as a teacher. Right?
So let me see if I get this straight. Does that mean then if the principal has an issue with you, that it should be just you and the principal, not the principal and the assistant? No,
the principal is not. This is not provided for the principal filing a grievance against you. I've had a time or two where the administrator tried to file a grievance. I said, well, you can file anything you want, but not by this law.
Okay.
But this law doesn't say that you can file a grievance. This law says that the teachers or certificated personnel can file against their immediate supervisor and then go up to successive levels of review. But it doesn't talk about anybody who's above you, a subordinate. It doesn't talk about a superordinate filing a grievance against a subordinate, okay?
Okay.
And I tell teachers, I've done this for years, for over 20 years, I said, now when you get in there, I know you're nervous, got butterflies, but as soon as that tape player goes on, you immediately say, well, the purpose of this meeting is to discuss the grievance which I filed on such and such date. I said, that's going to shock the principal, because first of all, the principal still thinks they're dealing with you in a vertical relationship, not horizontal. Because in the grievance thing, this is a horizontal relationship. They still think they're in charge of everything. I've had them in there, they won't hardly let the teacher talk. They want to talk about everything and run their mouth, and it's not even their grievance, right?
Yes.
They do it all the time.
They try to make it a referendum on the teacher's teaching skills,
right,
instead of what the teacher filed the grievance about against
and they want to cross-examine the teacher, but they say that. It says, again, go back to 20-2-989.8, paragraph 4, a statement that the complainant, not the administrator, that the complainant shall be entitled to an opportunity to be heard, to present relevant evidence, and to examine witnesses at each level. Now, it's just that simple. They would do anything they could to cut that law out, the administrators, school system, school boards. They hate this law. but they don't have the guts, I don't think, yet, even though they're still trying to come up with merit pay and stuff, right? They don't have the guts yet, I think, just to totally take the law and do away with the law. Okay? Now, we still got a few things with grievance law, and then I'm going to hit 940, 942, due process law, which Roy Barnes tried at his own endangerment and got defeated that year for doing that. He did away with the due process rights. Okay, let's keep going on grievance law. Okay, so paragraph 7 says the last sentence right there. It says the board of the local unit of administration, when hearing an appeal from the prior complaint level, shall hear the complaint de novo. De novo. That means a new hearing. Okay, that means it's not going to be like you file something in the federal courts, the state courts, where the courts, they finally, they look at something, they review the record, right? They always just review the record. They may grant certiorari. Granting cert means they may let you come before them, they may hear it or something, right? But most of the time they just review the record. Most of the time they reject hearing it, okay? So this right here means if you go to level 3, and all it says, the reason you go is if you're not satisfied. So I put down there, they'll say, well, why are you filing level 3 or 2? I said, not satisfied with the disposition of level 1. All you got to say is, I'm not satisfied with the disposition of level 1, and then you go to level 2 or level 3. And it says it's going to be a de novo hearing. De novo means a new hearing, okay? Now, Fulton County doesn't do that. We've been beating up on the cabin in Atlanta here lately a lot, okay? Fulton County doesn't do that. They have a tribunal to hear it, right? But the law doesn't authorize tribunal. It authorizes a tribunal in the 940, 942 law in due process. It says they can set up with former educators, people have the proper credentials educationally, to hear something. They recommend they could recommend their decision before the board. The board doesn't have to take it because ultimately the board's got to vote on whether or not a teacher's going to be fired or non-renewed. But in this case, it doesn't say that. It says the board hears a de novo. And so there have been some legal scholars on that who made statements on that and have copies of that. They said, no, the way it's totally read, the way you read this is the board has to hear this. But Fulton County over there, they'll just set up a little tribunal. I'm going to write it on the board, y'all know what tribunal is, so, and let a tribunal hear the grievance of level 3. And in Atlanta, I don't know how long it's been since they've ever had one go before level 4 in Atlanta. We were talking earlier, Atlanta comes up with an illegal level. They have 4 levels instead of 3 levels because they never want this stuff to go. You know why? They don't want this stuff to be exposed, how these administrators are treating teachers in the schools. Because if they properly go by the grievance law, you can clean up everything. It's a good law the way it's written. There's a few little things I would clean up on the law, and they've tried to do that a few times. But I know Representative Jordan has introduced something trying to clean up the grievance law, and boy, they don't want to touch this law. Okay. Again, Zell Miller had a few more guts than some of the politicians today. In '92, he got the legislature passed and he signed into law. Okay. Let's finish up this grievance law and go to another one now. Over there, look over there, 989.9 right there. Okay. And by the way, look at the last section of it, number 11, of section 8, number 11. It says a statement that a complainant, this is what one of the minimum requirements that each local school system policy should have. A statement that a complainant shall not be subject to any reprisal as a result of filing a complaint under this part, meaning this law. Should any reprisal occur, the complainant may refer the matter to the Professional Standards Commission. Used to be the Professional Practice Commission. They had changed that law because they did away with it. Zell also did away with the Professional Practice Commission. Everything got submerged into the Professional Standards Commission. So the PSC, if you file a grievance, you feel like they're coming back and picking on you, then you have a right to file saying this is a reprisal and go to the PSC on it. Most of the times when you file a grievance, especially when MACE, you put down there, and Mr. Scott said we're represented by MACE, you put that down there, most of the time, they ain't going to mess with you no more. I'm just telling you, I hate it ain't bragging when it's fact. I'm telling you, that's just what happens most of the time, okay? That's why I told you most of the time we don't have a hearing. We file these, we hardly ever have any hearings anymore. They want to resolve it real quickly. Even in that school, so I was telling you that banned me last year, they resolved on how many this year, right?
Oh, they're real friendly, yeah.
They're real friendly, right? And especially after the superintendent got fired yesterday, right?